Welcome to what is the first in our sessions on alternative dispute resolution. This session is on the Children's Arbitration Scheme, and I'm delighted to have Shiva Ancliffe here. She's a family law barrister of 29 years call, who specialises in children family law at Coram Chambers, and she's been an arbitrator since 2017. In addition, Shiva writes articles on arbitration both in the Family Law Journal and Family Law Weekly. Hello, Shiva. First, can I ask you to explain what arbitration is?
Yes, of course. So, put very simply, arbitration is, as you say, an alternative form of dispute resolution. What that means in plain language is that rather than go to court to resolve the issue that you and your ex-partner have between you in relation to your children, you can deal with it in a different way. You can use an arbitrator who is an independent person and appoint that person between you to determine the issue and avoid the court process entirely.
Is every case suitable for arbitration?
No, every case is far from suitable for arbitration. If there are complexities in the case, for example, there are allegations of domestic abuse, or one party or the other has mental health issues, or substance misuse issues like drugs or alcohol, or there are safeguarding issues, child protection issues. Those cases are not suitable for arbitration. The sorts of cases that are suitable for arbitration are cases where there are conflicts about contact between parents. These are just some examples, it's not an exhaustive list. Contact between parents, contact during holidays, school holidays with the absent parent, relocation cases both within the country and also internationally. The scheme has recently been expanded to include temporary and permanent relocations outside of the jurisdiction. The countries that covers are countries covered by the 1980 Hague Convention and the 1996 Hague Convention. Arbitration is also suitable for issues like change of school, so quite straightforward issues, and also potentially more complex issues with the international relocation cases.
So how's going to arbitration different from going to court?
Well, arbitration is designed to be more accessible. By that I mean that you and I both know, Sarah, when we go to court, that the process is very emotionally challenging for most parents. The court process is usually coming at a time where parties have had enormous challenges in separating from each other and all that goes with that. There are financial pressures that come with separation, and the pressure that comes from then having to engage in a process with the judge in the environment of a courtroom is very different to arbitration. So, for example, we know that courtrooms and court buildings have inadequate private spaces to be able to conduct conversations with our clients. Conference rooms are overflowing and booked. So we're standing in corridors talking to our clients in wholly inappropriate and lacking in privacy environments. We know that judges don't always manage to give continuity to cases. So whilst, of course, in a court case, the judge always tries to keep the case for themselves if they can. It's not guaranteed, and oftentimes it doesn't happen. So you'll have one judge hearing number one, and then a return hearing, there'll be a different judge. Those things don't happen with arbitration. The great benefits of arbitration are that the parties and the arbitrator have a great deal more control of what goes on within the arbitration process.
So how do you choose an arbitrator? How can you agree on one?
Well, before we talk about choosing an arbitrator, I just want to tell you a little bit more about the benefits of arbitration, if I may. So, for example, within arbitration, The parties choose their arbitrator. They will decide between them who the arbitrator will be. The arbitration process lends itself to them having information about the arbitrator. If the whole arbitration scheme is run by IFLA, which is the Institute of Family Law Arbitrators, and IFLA keeps the profile of all qualified arbitrators on their websites, which anyone can access, and the parties can then decide, with the help of IFLA, the arbitrator that they require, obviously bearing in mind the complexity of their case and the profiles of the arbitrators. And they then engage in the process. Now, the advantages of arbitration, as I've said, are the control that you have over the whole process. That means you not only choose your arbitrator, but once you determine the arbitrator, you choose how the whole mechanism of the hearing will be conducted. So, for example, it may be that if your case is very straightforward and the issues are very narrow and the arbitrator is content with you both to deal with it on the papers, that there is no need for an oral hearing. However, if there are evidential issues that require the arbitrator to hear some evidence, the arbitrator can decide with you how the evidence is going to be heard and how the evidence will be taken. Now, that can be in a very limited form. So again, it reduces the time spent in arbitration. We know that with the court process, when you're in a court hearing, there are fixed hearings that have to take place, what we call directions hearings. With an arbitration, the arbitrator, if the case is straightforward and is determined collectively between you and the arbitrator that you don't need those directions hearings, can avoid those. Or if they are required, there could be directions done on papers, or there could be directions done on a telephone hearing. So all of those things are available in arbitration that are not available in traditional court hearing. The environment that we work in as well, arbitration is much more comfortable. It's usually done in a barrister's chambers or in the offices of a solicitor, and therefore there's more than ample privacy and space to have all of those discussions that are required.
Thank you, that's really helpful. So if I want to find an arbitrator, if I want to go through this process, how do I do that? How would I find an arbitrator?
So the way to find an arbitrator is really through IFLA. IFLA has the profiles of all the arbitrators that are qualified. There are different schemes. There's the financial scheme, and then there's the children's arbitration scheme. The financial scheme's been running for quite some time now and is very well established. The children's scheme's been running since 2016, and all of the arbitrators that are qualified are on the website with various profiles. And obviously, when you are looking for an arbitrator, you look at you look at the experience they have and their experience as a barrister or a solicitor. Solicitors and barristers both qualify as arbitrators, and look at the complexity of your own case and measure the two against each other. By that I mean you aren't necessarily going to go to the most experienced person for an arbitration if your case is very straightforward, because there may be implications in terms of the rate of costs and the charging rates for those people.
Yes, I was going to ask, what's the cost of arbitration?
Well, the costs vary. Obviously, I would clearly say that the cost of arbitration is far less than the cost of a court hearing. Court hearings have hidden costs within them. Not only is there the issuing fee of issuing to go to court, there is then the cost of instructing your solicitor to represent you, the preparation of the case. There's the cost of interim application. So, for example, if you need an expert witness in the case, you have to issue an application in court called the Part 25 application. There's an issuing fee for that. Now, arbitration avoids most of those costs. So you don't have an issuing fee, you don't have interim costs of further applications. If you need an expert in an arbitration case, then the parties jointly meet the cost of that arbitrator. You don't have to issue an application. The arbitrator and the two of you agree who the expert will be, and the cost is met by you. Whether there is a need for a solicitor to represent you on each side in arbitration will depend on the complexity of your case. It usually is a good idea to have independent legal advice, even if you're going to an arbitrator, but it doesn't always follow in the most straightforward of cases that it's necessary. But that is something that depends on a case-by-case basis would be considered on a case-by-case basis. So I wouldn't say that arbitration avoids all of the costs of legal representation, because there are clearly cases that still would hugely benefit from representation, even in arbitration. But some cases, very, very straightforward cases, can be on a direct access basis. So arbitration does not rule out direct access. Direct access cases are the most straightforward, suitable for arbitration, but that would have to be something determined with an arbitrator that you approach as to whether your case is appropriate to be dealt with.
The direct access scheme, that's going directly to a barrister, is it, and not having a solicitor?
Yes, that's right, yes. So some very straightforward arbitrations might happen on that basis, and certainly the scheme doesn't preclude that happening, but by and large I would say that having legal advice and representation is still very useful. Now the cost saving comes really because the process moves very quickly and far quicker than a court process. So often the costs in litigation and the legal costs that ramp up on both sides is because there are endless letters written by both parties, by their solicitors, and then interim hearings in court where lawyers are instructed again for representation. With arbitration, as I've already pointed out, the whole thing is streamlined, and it might be that the arbitration can be resolved in one, potentially two hearings. It really does depend on the issues that are playing.
And so we all know that decisions that judges make are binding. Is the same true of arbitration? Are decisions made in arbitration legally binding?
Yes, they are. The arbitration itself is binding. Once the arbitrator has determined the issues, he or she issues something called a determination, which is the equivalent of a judgment. Right. And that does end the process in that the court recognises arbitration as a legally binding process. More often than not, the arbitration determination is transferred into what is a consent order, and then that consent order is approved by the court. And so it's submitted and then effectively transformed into a court binding order as well. But the arbitration itself and the determination is a binding process.
Thanks, that's really helpful. I think I'm just wondering whether there's anything I've missed, or whether you think we've covered all of the main topics.
Well, I think that this was an introduction to arbitration. It clearly doesn't cover everything that arbitration offers. I would really encourage anyone that is interested in arbitrating to contact IFLA. There's information on IFLA's website about arbitration, and really just to investigate more about arbitration, consider whether it's suitable for their particular case, and consider whether in the current climate that we're all living in of delay, regrettably you and I know, Sarah, that the court process, the family courts are inundated, and for some years have been inundated with work, which means that the hierarchy of priority is that private law cases sometimes go to the back behind more urgently, certainly considered by the court, more urgent cases of child protection, public law cases. And so there had been for many years significant delay in determination of private law cases, in children's private law cases. And the current climate of COVID-19 has set that back further, because as you and I know, there are no face-to-face court hearings taking place at the moment. And so there will be, in all probability, a very significant backlog and greater delay in private law children's cases being determined by the court. In the climate of the current difficulties in the court, I would say that arbitration has a real place and people should think very carefully as to whether their case is suitable for arbitration as an alternative and far more effective, speedier way to have disputes resolved. So yes, my advice would be investigate further and consider whether your case is suitable for arbitration.
Thank you very much, Shiva.
Pleasure. Thank you.